The Bobby O Show.
Welcome to the Bobby O Show. My name is Bob Potzner. I'm an attorney in Danbury, Connecticut with the firm of Collins and Hannafin, and I have a very special guest with you today. Laurie Gallo, who's an attorney in the Danbury area, who's a very experienced attorney in the divorce area, as am I. We are involved in a program that helps people reach the resolution of the divorce cases through the court system in a process called the Special Masters Program. It's a program in which experienced divorce lawyers in the various judicial districts, we are in the District of Danbury today, help other people with their attorneys reach a resolution of their case, if possible, in order to try to avoid trials. About 90% of all divorce cases are settled, but some have to go to trial, and the Special Masters Program is one that's useful in trying to help resolve your cases. And before I introduce Laurie to you, we do have some ethical requirements. As lawyers, we have to get continuing legal education for divorce processes. And so therefore we have to get one course is in the ethics area. And I'm going to read to you something that we're supposed to read in order to make sure that everyone knows what we're doing. And that is the information that Laurie and I are providing to you in this program today is general. Legal questions are fact specific, and seemingly unimportant facts can be outcome determinative in real disputes. Under no circumstances should you assume that the information in this program is a viable substitute for legal advice you would receive from an attorney that you engage for a specific issue. In short, we are providing you general information and not legal advice that you can rely upon. Okay? Having said that, we're going to tell you what we can, the best we can. Laurie, welcome aboard.
Thanks, Bob. Nice to be here.
It's always a pleasure, my friend. Laurie, tell us a little bit about yourself.
Well, I am an attorney that does a lot of family law work. And I went to law school at Pace University, and I've been practicing here in the Danbury area since around 2001. I started in New York, and I'm also admitted in New Jersey, though I don't do any work in New York or New Jersey these days. I practice primarily in Connecticut. And the most exciting thing about me is that I just got my LLM, which is an advanced degree. It's called a Master's of Law from Pepperdine University, which is out in Malibu, California. So my LLM is in alternate dispute resolution.
Well, I would ask you the question, if you had to go to Malibu, California, I wonder how much time you spent on the beach versus studying. But knowing Laurie, she studied fastidiously. I will say the most important thing for me about Laurie is that when you go to her office, she always has purple pens and purple pads, and it's always fun. The interesting thing is that Laurie and I practiced in law, she said, since 2001. I was practicing before she, but in the 22 or 23 years that she and I have practiced law, we've had many divorce cases on the other side of the cases, and we've had short arguments, short discussions, short disagreements, but we have settled every one of our cases, to my recollection, sometimes with the help of special masters. One thing that Laurie does is that she's in charge of the local special masters program run through the court system. And Laurie, just tell us a little bit about what is special masters and how is it useful in the divorce process to help people reach a resolution amicably in their cases.
The special masters program is a relationship between the attorneys that are well-versed in family law and the court. So what the court does is that the court will schedule a special master's date, which in the Danbury court always happens on Friday mornings from between the hours of 9 a.m. to 1 p.m. And we don't do it the last Friday of each month, but most of the other Fridays we do it. And the court will order in cases that are not having to do with custody issues. So custody either isn't part of the case or it's already been resolved. So strictly financial issues, the family court judge will order that the parties must participate in a special master's session. Now, the special master's sessions are about 1 hour long, and they are facilitated by two attorneys, always a male-female combination, that are well versed in family law, as I said before. And what does that mean? It means that they've been practicing at least 10 years doing family law and that they are well respected in our local community. And these two attorneys will listen to oral presentations given by the two attorneys that represent the people that are having a dispute over family finances. And after the presentations are over, then the two special masters will take a short break and they will talk to each other. And then they will come back and they will give an oral recommendation as to what they think is the best financial mosaic for settling this particular case.
You 1 second, because there's a few things I want to cover. First of all, pre-COVID, this was always taking place in our judicial district in Danbury, in the courthouse, literally on the second floor in a specific room designated for that. Since COVID, we've been doing it remotely, and even though we're now not in the quote COVID area, we're still right now doing the process remotely. And number two, and Laurie said we spend about an hour, more or less, an hour and 15 minutes per case, and usually it's 3 or 4 cases assigned each Friday that we do the special masters. We do spend more time than that, and the way it's set up in our system in Danbury, and each district does a little bit differently, is that the lawyers who are the masters get the paperwork, which we'll talk about in a moment, usually on the Wednesday evening before the Friday special masters. So I, for example, and I know Laurie and I have done many cases in which we've been masters together. I'll spend a good half hour or more with each case going through the papers we receive, the financial affidavit, et cetera, so that we're prepared for the process. And one critical, I've been special mastering in many of the judicial districts, Waterbury, Danbury, Milford, other districts as well, and so is Laurie. But we have a special process that we think is very successful in Danbury, and I want to get Laurie's opinion about this, and that is we require that when the attorneys are present with their clients and the masters, the clients are also present. Laurie, do you want to explain why we require that and why we think it's more successful to have the parties be present during the special masters program?
Well, a couple of reasons, Bob. First of all, when the attorneys are doing their presentation, their oral presentation, which supplements that paperwork that you referenced before that the special masters has looked at on the Wednesday evening, they're there to hear what their attorneys are saying and what the other side's attorneys are saying. So it's important sometimes for clients to actually understand and hear what the other side is saying, because sometimes you're so engrossed in your own narrative that you don't even hear what the other side is saying. And it's important for the parties to also listen to the questions that the special masters may ask during the presentation. They may need some additional information. And it's important for the clients to sometimes supplement what their attorneys are saying and answer some of the questions themselves. And then lastly, when the special masters come back and give their oral recommendations for settlement, it's important for the parties to actually hear what the special masters are saying. I have done special masters, as you mentioned before, in other jurisdictions where the clients were not invited into the room. They were asked to just stand in the hallway while the two attorneys went in to speak to the two special masters. And personally, I found that that was less effective. The clients didn't feel like they were part of the process, and the clients didn't actually hear directly what the special masters were saying. They got the watered down version from their own attorneys.
And Laurie, I think that's important because some lawyers I found, and I've obviously been mastered many times where my clients and I are there and I've been the master. Sometimes when I'm mastering and there's some judicial jurisdictions, in fact, most don't have the clients there. I've seen sometimes lawyers, maybe not on purpose, maybe otherwise, but they don't always tell the clients what's happening. So it's very important, I think, for the other side to hear what I'm saying about the case, etc. And number two, I think that when you hear what's going on, when I go to the master's program, I can't speak for you, Laurie, but when I'm being mastered, it's my client's case is being mastered, I may say, client, I want to make a proposal to try to resolve the case. But maybe my proposal isn't what a neutral might think. And so sometimes I'm going to be the special master, my client's being mastered, and I want to hear if you're the master, Laurie, what do you think? Am I making a comment that makes sense? How would that comment play before the judge? And the thing is, we don't always know if we're the attorney, have a client whose case is being mastered, which judge will be the judge who decides the case if you go to trial. And our experience in Danbury and in most districts is that every respected judge has a different perspective because the laws in Connecticut, it's not a cookie cutter. There are statutory requirements for how you determine alimony and support and child support and those kinds of things. But it's a very factual intensive situation. And we know from experience that more likely than not, Judge A might say, no, I think the term of alimony should be typically from X years to Y years. Another may say something different. And we as lawyers have to filter out not knowing who the judge is going to be, but trying to understand, am I making a good approach for my client, or maybe I should do it differently? Laurie, any comments about that when you're being mastered?
When I'm being mastered, I really appreciate the expertise that the two masters give me. And I kind of look at it as like a first bite of the apple. Because if I hear that the two masters are going to give a recommendation that is significantly different than what I had suggested in my paperwork, that's going to give me pause. And that's going to make me think, okay, I'm really advocating for my client, and I'm perhaps really saying what my client would like, but maybe that's not likely to be what a judge is going to say. And when those two special masters come in significantly different than what I've come with as a proposal, I have to step back and say to my client, listen, we have to think about this. We have to give this some serious consideration, because if these two experienced attorneys are looking at it very differently than we are, we might have some exposure at trial.
And, we talked a little bit ago about what is presented to the masters. We're going to get into that right now. And that is, there are certain statutory criteria that a judge must consider in things like property, distribution, and alimony, if alimony is appropriate. And there's also child support issues that could come up. As Laurie said, we don't, as the masters, deal with parental contact issues. But the statutes list for alimony and property about 15, 16 different factors the court must consider. And we typically, in the master's program, when we get papers, I said we get on Wednesday night before, it's a list of however either side wants to present the certain important facts of the case. I had a form I was going to show you, but we're not going to do that. But essentially, there are things like how old are the parties? How long have they been married? What are the kids' situation? You get those facts because remember, the parties have lived this case for whatever the length of the marriage is going to be. We've never seen the case before. In fact, if I know the case before, I have to be conflicted out. So, Laurie, why don't you explain a little bit about the financial affidavit that gets submitted as part of the process that we consider?
Financial affidavits are done in every single divorce, whether there are children or no children. And these financial affidavits are completed under penalty of perjury, so they have to be completed accurately. They also cannot be older than 30 days old when we're going into court for any kind of an appearance. So they periodically, during the pending divorce, have to be updated. So as a special master, we expect to receive an updated financial affidavit that is completed correctly and completely with the most accurate information possible and most recent information possible. So the financial affidavits include things like the income of the parties. So each party is going to do one of these forms themselves. So it's going to have the assets of each party, including things like bank accounts, retirement accounts, stock, any kind of deferred compensation, meaning 401ks, pensions, IRAs, that sort of thing. Also, restricted stock units and things that may not be vested yet need to be put on your financial affidavit.
What does vested mean?
It means that they
I
have
know. I just want to. It's for the audience.
not yet mature. So, for instance, somebody might be given stock by their company, but it has a 4-year vesting schedule. So perhaps they got $100,000 this year, but it only becomes mature at 25% of it over the course of 4 years. So the 25,000 this year, 25,000 next year, and so on until it is fully vested. So even those things that are not yet vested need to be divulged on your financial affidavit.
And Laurie, that's why we as lawyers have to be updated on the law, because several years ago, if it was an unvested item, it might not have been considered by the court. And that's true with unvested pension issues and whatever. And that's why there needs to be the financial affidavit provided. I once made an analogy to Perry Mason, and some young person said, "Who's Perry Mason?" But I'm going to take a shot. And Perry Mason used to have a guy named Paul Drake who often would come into the show at the end of the show with, "Here's the secret information." Well, we don't have that kind of thing anymore. Right. We have to be full and fair disclosure. And sometimes at the special master's program, one lawyer or the other will say, so-and-so is not giving me the documentation I need. And we often will set certain time limits because the judge would do that. I do want to say, Laura, that once we get information, and there's a lot more information we would want to have, when we make our recommendations, ultimately, when we have our break and the lawyers discuss things, and we sometimes will have disagreements, the ones who are the masters, whatever recommendation we make, if the case does not settle, the judge will never know what we recommend. And that's very important because we want to have the lawyers and the parties feel comfortable to really have their case pre-tried and given some good recommendations. Can you talk a little bit about the privacy issue that is maintained, Laurie, in the process?
So if I may just go back to that financial affidavit, we were talking about assets. Also, liabilities need to be put on the financial affidavit. So things like credit card debt, personal loans that might be owed to someone, anything of that nature, car loans, boat loans, all need to be divulged on the financial affidavit, as well as insurances that you have, like life insurance. So all of that needs to be put on the financial affidavit. So these financial affidavits, as well as this paperwork that we've been referencing, all need to be handed in by Wednesday at 5 o'clock by the two attorneys that are making the presentation. So what does that mean? The two attorneys are going to present their proposed orders, meaning what their wish list items are, as well as a pretrial memo or brief, which goes through the things that you were talking about before, Bob, things like the age of the parties, the health of the parties, the work background of the parties, etc. So that's a lot of personal information that we've now just given to these two attorneys that the parties don't know. So we have a form that explains to the clients that we are going to, as when we're special masters, we are going to destroy any of the information that has been presented to us in any kind of written format. And we are not going to obviously discuss the case with anybody outside of that format. And anything that goes on in the special masters meeting is considered a negotiation. So anything that happens in that meeting cannot be used in terms of a trial down the road. So the special masters cannot be called as witnesses to testify for either party and say, well, Bob offered this and Laurie said that. That's not allowed. Anything that happens in special masters is considered a negotiation and not subject to any kind of disclosure in the trial.
And another thing is, under the laws in Connecticut, if you reach a settlement in your case, and going to special masters does not break the rule for this. If you settle your case, your financial affidavit that will be filed in the court system, there's a way called the judicial website in which all of the pleadings and paperwork in the case are on the judicial website, but only the parties and their attorneys have access to that, except there's some ways to get some of the documentation. But the financial affidavits that are submitted by the parties are secret unless you go to trial. Once you go to trial and start the trial, then the affidavits are public records. And I've had cases, Laura, I bet you have too, where people have settled their case not the way they wanted to settle necessarily, but because they didn't want the world to know, for example, their finances. And that's something that's important. The other thing is, in Danbury, and every other district has a different rule, we only special master cases in which both sides have attorneys. You could go to court if you wanted to get your divorce. Any parties could, and you could be self-represented. But unless both parties have an attorney, then we don't special master. And Laura, do you want to explain why we have done that rule, implemented that rule? And I think it's a good rule that we have.
The option that's available to pro se's is that they can, instead of doing special masters, if there were two pro se's involved, or one pro se and one attorney, then they have the option of going to the family relations office for a family relations pretrial. And that's a free service that's offered by the court. We do it only with attorneys involved, mostly because we need it to be efficient and expedient. The attorneys that are involved know the paperwork that has to be submitted. They understand that the financial affidavits have to be accurate. Many times they also include, if children are involved child support guidelines and perhaps some alimony alternative worksheets. So it just wouldn't be an efficient 1 hour if we were dealing with pro se litigants that didn't have all their papers in or were not fully prepared.
It's very important, as you mentioned, that when I'm being mastered, I take the master's program, as does Laurie, because I've had cases with her. We do a lot of preparation. My client and I, we treat it as though we're prepared. From my perspective, when I'm being mastered, I'll tell my client, look, if the case doesn't settle, let's use this opportunity to get ready for trial. We don't do the trial notebook, which we can talk about in another session, but we do prepare, and a lot of time is put into it. Some lawyers choose to do it differently, and that's their right with their clients. But I find when I'm being the master, if you're more prepared and you have the answers to the question, and let me tell you, I could tell you, just like when I was a senior at Yale, I could tell you 80% of the time what the questions were going to be asked in my poli-sci exams. I could, that's new. Laurie and I know what issues in our case are issues that are going to be, a little bit queasy, a little bit, whether there's an accepted or not, but we need to be ready what the other side say. If I have a client who makes $1 million a year, it could be husband or wife, and the wife makes nothing for whatever reason, and she makes nothing because maybe they've chosen to have her be the housemaker, or vice versa. If the person making $1 million a year says, well, let's go in and say no alimony in that situation, and alimony has a lot of different factors. If you go in like that, it's difficult for clients. So we try to be very prepared. We try to anticipate the problems, but if there is a reason why in that case it's unique and why it shouldn't be a case with alimony, then we present it, and that's what we're prepared for. Laurie, any comments about that?
Nothing further about it, Bob.
For you folks to hear Laurie and me disagree so quickly, it's really a nice thing. It must be because the Christmas and Hanukkah holidays are forthcoming. Laurie, let's talk a little bit about why we spend our time as lawyers volunteering for this program. We don't get paid for it. And I do, by the way, and I think you do also, we get hired in cases where people actually pay us to act like a special master. It's called private special mastering. I get 3 to 5 cases a year. You probably do also, Laurie, where we get hired by lawyers and their clients. They come to our offices, whatever. But why do we do this pro bono? Why is this that we do this, Laurie?
Well, for a variety of reasons.
Why do you do it? Tell me why you do it, perhaps.
I consider it a great honor to be a special master. I was honored when I was first invited to be a special master. Um, and in addition to that, it really gives you insight as to the other attorneys that are practicing in the area. You get an idea of how well prepared people are. Um, so I might be a special master in this case with attorney X, but then 6 months from now, I might have attorney X on the other side of a case of mine. So it's always interesting to see how other people make their presentations. It's also a way for us to learn new things. Um, Bob and I, we've presented many, many times together, opposite each other, and we've also special mastered together. And it's always a great opportunity to learn something from each other. Ever since COVID, we have not been required to spend as much time in court as we used to pre-COVID. And so as a result of that, the ability to spend some time together and talk to each other and learn about the latest cases that have come down, or have you had this experience? Have you had that experience? It's always great to have that opportunity to talk to one another as professionals.
Laurie, you said it very well. I learn more when I am the master. Things I shouldn't say.
Mm-hmm.
I think we learn a lot, but also, people. The polls say that people like their own lawyer, but don't like lawyers in general. And people don't realize how many hours of volunteer work we do. Well, we have about 2 minutes left, and I want to talk to you for just a minute or so. How does one become a special master? Who's eligible to become a special master? How do we pick in Danbury the special masters?
In Danbury, our requirements are that the people that are interested in becoming a special master have to have 10 solid years of doing primarily matrimonial work, have to be experienced people that are actually trial attorneys, that are familiar with the courts, that are familiar with the judges, that appear regularly in front of the family court. And they have to be vetted. So if somebody is interested in becoming a special master, we in Danbury, actually, the special masters that are current will vote and determine whether or not that person is going to join us as a special
And
master.
by the way, in our last 30 seconds, it's not a popularity contest.
No, it is not.
Laurie, I want to thank you very much for coming on the show. This is a very special time of the year with the holidays, Hanukkah and Christmas, etc. And I'm going to have the pleasure in the next several days of having a second grandchild. And I think Laurie recently just had another grandchild or child or two recently. So there's a great time of the year. There's a lot going on in the world now. There's a lot of things that are difficult, but you know what? We should be happy with every day and enjoy every day we get to breathe. Laurie, thank you very, very much. I'll have you back on the show. We'll talk about some more things in detail. I want to thank my directors, Jonathan and Candy Ann, for the work they do for me on the show. And wish you a healthy, happy Hanukkah and Christmas. This has been Bobby O on the Bobby O Show.
Thanks, Bob. Nice talking with you.